you know, we had a bunch of exhibits that we admitted last week that we have not admitted in front of the jury. And so we need to do that before we do closing argument. Just from my recollection, we had 2027A was not admitted, if memory serves. Is that check with everybody's record? And then we redacted a number of these other ones. I think there's another like 9 or 10 exhibits. And my understanding is this is the redacted exhibits. Is everybody a chance to look at this and make sure that they're redacted properly?
I haven't seen that.
All right, well, I make sure.
We have not as well.
Okay. Before I hand these to you, and I don't mind doing that, I'm not sure if these are numerical order or not. I'm not sure what they are. But before you hand those over to them, just this moment, you may have seen Mr. Conrad hand up to the bench a couple of pages from medical records, and it looks like it's from Exhibit 981A. Are these, what are these? Are these something else you want to add to the exhibit, or what?
Judge, so 981A was admitted, but we accidentally left a couple pages out inadvertently. So I'm asking that those be added to 981A.
Your Honor.
Have you seen these, Lori?
I was handed in this morning with the request, and the state doesn't have an objection to the first page, which I believe is 86. The state does have an objection to the following 2 pages, which I think, I don't have them in front of me at the moment, but it should be.
Oh, there is 2 pages. There is three pages. I thought it was only 2. Okay.
And the prior problem list, I think, isn't relevant and has been documented in several of the other exhibits that have been provided. The court is admitting, but we don't have an objection to the first page. And I apologize, I have a cough drop, so sorry about that.
No problem. How did these get omitted? Were these omitted to what, I take it that both parties have had the whole record,
Correct. As the court knows, there's
981A. As I said, did you hand those forward?
Did.
Yeah, I said not to do that because I
Oh,
thought there was something up here. I also noticed that the order in which these are in here are not in accordance with the page numbers in the bottom, that are out of sequence. Should they be placed in a sequence? Which I'll do. Now then the question is are we going to add these other 3 pages? Well,
Judge, that
maybe I won't do that for now. Anyway, go ahead.
I'm sorry, what did you say?
Maybe I won't change the order in those pages after all. Mrs. Winnie's marked one of them with a, not marked, but clipped on the exhibit tag.
So, Judge, his problem list of issues that he's dealt with isn't covered in any of the admitted documents that I saw. I thought originally that it was in the autopsy report, but it's not. It's been testified to, and I think it's important that the jury has the documentation that supports the testimony as well.
Well, before I go to the state here, did any of the defendants, do each of the defendants also know what's being proposed here?
Yes, Judge, and I have an objection. No objection.
Okay. Miss,
Your Honor, there's
Go.
no evidence that it was relied upon by the doctor who was treating him on the incident from September 2019. And there is documentation in the testimony and in the medical examiner's report regarding the concerned areas of prior existing issues. Not as explicit as in there, but some of that isn't even accurate if you go back through and look at the other medical records.
Anything else, Mr. Conrad?
Judge, it's not contained within the medical examiner report. When testified to, it's important that there's a document that supports it. It's a business record, they're documenting what they've seen in the records. It's relevant. His medical history is relevant, and so come in with that document.
I would note that, at least in 2013A, in the history obtained from the patient, history of asthma, anxiety, chronic viral pericarditis, pneumonia, IV drug use. I mean, and this is from 2017, so all that, those issues are contained in the records.
Yeah, well, I know some of it was covered, even if not quite as complete as this list on 147 and 148 of Exhibit 981A. Well, I'll admit it. I'm going to put them in the numerical order of their page numbers, though, when I do so. So these three new pages will go at the end of the exhibit, but I'm going to move, which had been the original sort of page 3, to the front, because it's page 44, and the first page of this exhibit was page 48, and that's the one that got the exhibit tag on it. And I'll ask Mrs. Whitney to move the exhibit tag from that page to the other page, and then that'll be the exhibit.
You're on the one that's-
Oh, and here's the, absolutely. And here's the cover, little blue cover sheet that goes with it. And then let Lori have that all. Okay.
Is it okay if I step back from the bar and I'll bring them back? These I've reviewed, they look consistent with redactions.
They look fine?
A quick look at these.
Good.
And then, so Lori's got 2 of them.
Yeah. Don't mess that pack up, though. Give it
And
two.
I'll need that back too.
You need this back?
I'll need that back, yeah.
I need this.
Exactly.
Don't go far away with that, because I'm
Oh,
gonna
no,
need
no,
it.
you keep it, but
You need it
we're
later.
gonna, because
I won't.
even though we did those documents on December 6th, we've got to do it in front of the jury, I gotta change the date, so I need to make sure I have.
That's fine. Counsel, if you guys want to take a look at these redacted exhibits, why don't you come forward to here and do it here, instead of handing this all around. And don't intershuffle it with these other exhibits that are sitting up there. Please not.
Those are not, these are reports. These are all in my court. I've got a few. Did you just look at this one?
Saved in the world of the traditional copy.
and state has reviewed the medical records exhibits that with redactions and they do correct based on our recollection of the court's rulings.
Thank you, Ms. Kleiman. Ms. Nicolavo,
That's fine.
sorry about that.
Where's Sean? Can she go outside to get the device? Sean? Can you go get the hearing device from Kayla outside the courtroom doors? Okay, thank you. Oh, is she out of these? Oh, okay. Actually, we can just,
Can you get by me?
that was great. I did everything like that. Oh, no, no. Judge, Any chance for Tony back down here?
Yeah, Mark's here.
Okay, so you'll be just sent,
Yeah, have him reach out to Mark.
okay.
Yeah, that's it. Yeah. Judge, I'll look through those look consistent.
Okay, we'll put it on the record in a minute then.
You just put it in there.
Because he's still waiting to come out. He found out further. What's Mark's extension? Can't be found.
Should be 6 foot, so.
See it in the photo registration.
He's on it.
Okay, I just gave.
All right, are we set? Just-
Yeah, yes, Judge, that's fine.
Okay, so you're making me nervous here. What are you doing, Mr. Conrad? I would say when you're done with that packet set, And I would have thought of all the people that you would have been the first council done with them. Since you're the one that put them together, then give them to Mrs. Winnie so she can mark them properly. You looking for something?
What's that?
This is yours, this one.
You can put them right here if you like. But I'm not sure I'm going to need to pick them up. Okay. Has everybody had an opportunity to review all the exhibits, including the last few pages, and to make sure that they're properly redacted? I'll start with the state. Mr. Clavo.
Medical record exhibits.
I'm sorry.
The state reviewed all the medical record exhibits, and they are properly redacted based on the court's prior ruling.
Understood. Okay. Ms. Burcher.
Judy, the defendant really agrees.
Mr. Rosser.
Judge, I had a chance to review those, they seem consistent with the court's ruling last week.
I'm sorry, can you repeat a little slower, please?
Yes, I had a chance to review the exhibits that are consistent with the court's rulings last week. Thank you, Judge.
And Ms. Conrad.
Yes, Your Honor. Same thing.
Okay, so Exhibit 981A, 984A, 2005A, 2006A, 2013A, 2016A, 2019A, 2026A, 2028A, and 2029A are admitted. 2027A was proposed, and the court did not admit that, and it's not part of the parcel here. So those will be admitted, and when the jury comes out, we'll tell them that, so they will know it as well. Now, before we get to exceptions, I had at least one motion here. I got a motion from Defendant Rankine to dismiss this case for prosecutorial misconduct. It was filed, I believe, last Thursday, or at least handed to me last Thursday. Mr. Liu wanted some time to look at it. And I said, well, we're going to meet here again on Friday. Let's see how we do. Of course, we were busy doing other things, and we never got this far. So, Mr. Liu, I hope that at this point you're now ready to talk about this.
I am, Your Honor.
I guess I should hear from them, the moving party first, and then we'll hear from you. Mr. Conrad, is there anything you want to add to your written materials?
Well, Your Honor, I think I had some additional time to look at the record and look at the case law and support. And then so I wanted to provide the court with some additional briefing on it, just to, I think, highlight some of the issues that were present during it. I think my brief covers a lot of that. I mean, the court found that it was a violation of the motions in limine, that it was a comment on our client's right to remain silent and right to counsel. And then the question is it, well, it's presumed prejudicial, and is it, can we say that, well, the state has to then prove. I think the standard is beyond reasonable doubt that it's not. And in this case, I think what's significant is the fact that Officer Rankin.
Well, that might get you to a mistrial. Does it get you to a dismissal?
I believe so.
Okay, go ahead.
I mean, when I was looking at the case law, it's a bit unclear, but I think you start with the standard that if there's a comment on a constitutional right, what do you do from there? And so.
Well, usually, for instance, when that kind of thing occurs, and the Court of Appeals is looking at it, they don't say we're remanded to the Superior Court to dismiss, with instructions to dismiss. They say it's remanded for a new trial. Now, they could, of course, say dismiss, depending on the nature of the violation, what other evidence may or may not be available in the case, and all the surrounding circumstances. I don't think it's beyond their power to do, but I think that's fair to say.
It's an interesting question, because if the mistrial is granted, then the question is, has jeopardy attached? Answer that is yes, and then you look at the dynamics of whether retrying the case would be prejudicial, I think, towards the defendant again, given the circumstances of the case and the issues and importance.
Well, this is kind of the conundrum you had the last time. Do you want to ask for a mistrial or don't you?
Well, I've already asked for mistrial, and I think the court's already ruled on that.
Are you asking for it again?
So I'm asking for a dismissal.
Okay.
And the reason I'm asking for a dismissal is because of the cumulative effect of the prosecutor's behavior throughout this case, and it starts with pretrial, and we filed a number of motions based on their misconduct and discovery, based on withholding of evidence. We're still pending a sanctions motion on continuing to redact documents that they said were work product or attorney-client privileged, and then turned out they were not. And then throughout this case, we had a number of comments. One was by Ms. Nicolavo. I think if the court remembers, that was it, asking questions of an individual investigator that had taken photos, and we had, and that was a cursory comment on the right to remain silent during the questioning. I think the court cautioned the state about that during that time period. And then there were the comments to Mr. Nielsen, as well as the inflammatory comments about the 2015 and 2019 incident. And the issue here as well is whether, I think it's pertinent whether it was intentional as well. And if you look at Ms. Eak's argument more closely, and that's why I think the transcript is important, is that when the state was asked to explain why they did what they did, Ms. Eakes initially said, well, the door was opened on this issue. And so she's admitting at that point that she knows she's commenting on his right, that she's done it intentionally, despite the court's directive and order that if a party feels that a motion to eliminate, that the door has been opened to it, that we discuss it outside the presence of the jury. So that's what she initially says, is that the door has been opened. Then she starts to backtrack and say, well, I wasn't commenting on his right to counsel. I was saying that he should counsel himself, which the court found not credible, because it's not. And then she said, well, I wasn't commenting on right to counsel because I was talking about a union representative that was never present at an interview, which Ms. Eakes knows well. That's not true. There was no union representative. The only other person present there was counsel. So if you look at what the intent of Ms. Eakes is, it's from the get-go the intent to comment on his right to counsel. And I think that in that scenario, is it prejudicial? Given the evidence against our client, which is his statement, and that's why I moved on corpus delicti on halftime. It's the statement and his testimony are the crux of the state's case against him, and now they've tainted that with this cross-examination. So how could you not say it's prejudicial? It's intentional, it's prejudicial, and I think given the history involved and the cumulative effect of what the state has been doing in this case, that a dismissal is warranted under 8.3.
Any other defendants weigh in on this?
Judge, only I joined in I did move to dismiss on behalf of Officer Collins for the same reasons. And the court asked a question of me as to how it has prejudiced Officer Collins, given that it was a comment on Officer Rankin's right to counsel. And I still maintain that by inference it's the same as it relates to Officer Collins, because the same redactions are in his interviews. His statement is 6 days after the event. He has counsel present. And so by inference, the same circumstance applies to Officer Collins as it does to Officer Rankin. Again, there's no guild representative there. I mean, it's clear in the transcripts that that's not true. Ms. Eakes knows that's not true. It's clearly a reference to right to counsel. And so then the question becomes, what's the appropriate remedy? And I think the SB case is particularly enlightening, because I think the court there, I think it was Judge Warswick, no, she might have just joined in it, but The judges there had indicated that if they don't grant a mistrial and a new trial in that circumstance, then what's the deterrent effect as it relates to what the appropriate remedy is? And as I stated, when I made the motion to dismiss, it's clear to me this was done with an eye towards a mistrial. It was the very last witness that the defense was calling. It was a redirect on the very last witness that the defense was calling. It's clear to me it was aimed at an attempt for a mistrial and a do-over. And I think if that's the case, I think the court was clear that that would be a basis for dismissal. And so I joined the motion. I don't think there's any other remedy that would deter this similar conduct. And so that's the basis for Officer Collins joining, Judge. Thank you.
Okay. Mr. Pertzer?
Yeah, I don't have anything to add, but I would join the motion that Thomas would made regarding the damages to Officer Burbank as well. He was similarly situated as Officer Collins and Officer Rankin. He had counsel present with him at the time of the interview, so the same arguments that have already been made apply to Officer Burbank as well.
Okay. Mr. Liu?
Thank you, Your Honor. All right, this matter was argued before the court last Wednesday. Same exact arguments made as Mr. Conrad's pleading. Again, Mr.
Can I interrupt to say, and you think I was right?
Yeah, exactly. There's no
Okay.
reason for the court to reconsider your decision. You already made the ruling. It should stand, and counsel has not provided any new basis for court to reconsider. Thank you.
You get the last word. If you want it.
No, Judge.
Okay. You can do whatever you want with this, I don't care. Bring it back here or not bring it back. That's fine. Okay. Well, I don't know that I have to say a whole lot about this. I will adhere to my prior ruling. I guess, one thing I didn't say, but occurred to me at the time, thoughts sort of roll through your brain, and sometimes they come out your mouth, and sometimes they don't. And a lot of times it's a good idea if they don't, if they don't come out. But one of the things that I thought about this, and one of the reasons why, you remember at the time I had the reporter read the question back and the question before it back, because I wanted to have the context of it. But I also thought the manner in which the question was asked, or maybe not the manner, that suggested it has something to do with with Ms. Eek's tone or body language or something. What I mean by that is, literally the words seemed a little awkward, and therefore it was a little ambiguous, potentially, as to what she had in mind here. And the question was, and you had 3 days to be able to consider and counsel before you went in for this interview, correct? And Mr. Rankine, who was the witness, she answered, "Can you counsel? ? I don't know what that means." And then then she proceeded with other people in the interview room, and then there was the objection. And I thought, in the entirety of this, I think I knew what it was, and I think it was a violation of the order in limine, and I stand by that. But I still think this was one of those things that sort of slips out in the heat of a moment and really wasn't done in a calculated way to try to get a mistrial. If I had, then I would have granted it and potentially then this is dismissal, because it would have been a way to try to get a do-over without actually dismissing the case. And that, of course, is inappropriate by a prosecutor. But what I didn't say was that the way in which they came up in sort of an awkward way, and even in which Mr. Rankine didn't understand it, at least initially, suggested to me that the impact on the jury would have been less obvious and unclear. And that's among other reasons why I thought that the prejudice to the defense and all the circumstances of the case did not justify either a mistrial or a dismissal. And so I offered the curative instruction as a remedy. Understandably, the defense did not want, accept that, but that was at least a remedy that they had and chose not to have. Even if I had thought this would justify dismissal, it only would go to Mr. Rankine, not to the other lawyers or other parties. But I'll deny the motion. And, okay. I know there was a motion with respect to motions in limine, but before we get to that, we do have the instructions that we've been working on a great deal, and even this morning, there were a couple of typographical errors that were noticed, and as I understand it, to the instructions, proposed instructions 34 and 35, and my understanding is that's been cleared up, and everybody agrees there was a typographical type error. And so we've made the change, and I've got that in the packet to go back to the jurors. So is there any other comment about an error that may have been made, just to in terms of typographical or otherwise, with respect to the instructions?
No, Your Honor.
Okay.
No judge.
Okay, so I'm sounding not. So, so does the state have any exceptions to the court's failure to give a proposed state instruction?
Yes, Your Honor. State would take exception to jury instruction number 23 with regard to accomplice liability. The court indicated.
That's the court's 23.
Yes, court's instruction number.
Well, before we get to my proposed instructions, is there any state instruction that you offered that I'm not giving that you think I should have given? And then I'll ask you about the court's proposed
No,
instructions.
Your Honor.
Okay. So is there any exception to the court's proposed instructions? And that's where 23 comes in,
That's correct, Your Honor.
right? Okay.
And the state takes exception to the court's determination that defendants Burbank and Collins cannot be accomplices to defendant Rankin's actions. As the instructions itself notes, that a person can aid in the commission of a crime by being present at the scene and ready to assist. And there can be an accomplice for the crimes of recklessness and criminal negligence. And there is substantial evidence here for the jury to find that Burbank and Collins were present at the scene and ready to assist defendant Rankin's conduct, which they knew was reckless and dangerous to life based on Mr. Ellis' repeated pleas that he couldn't breathe. All three of them together restrained Mr. Ellis, placed him in the prone position, knowing Mr. Ellis was having difficulty breathing. Despite Mr. Ellis indicating that he was having difficult breathing, Burbank and Collins then say they step away, but Rankin stays on top of Mr. Ellis. Again, despite all three officers' training that they shouldn't do that to someone in the prone position, and after hearing Mr. Ellis say, "I can't breathe," Burbank and Collins stands by near Mr. Ellis and Mr. Rankin, ready to assist. In fact, at some point, someone calls for a spit hood, and Officer Burbank goes looking for a spit hood, which again shows that he was ready to assist. Collins, at some point, we know he was still at the scene because he observes injuries to Mr. Ellis. I believe he indicated in his statement that he observed blood from his mouth. So this is reckless conduct, and there is substantial evidence here to allow a jury to determine whether Burbank and Collins were accomplices to Officer Rankin's continued restraint of Mr. Ellis in the prone position. Thank you, Your Honor.
Do you agree that, as the instruction describes, that none of the non-defendant officers were an accomplice to any of the charged officers? You agree with that?
Yes, Your Honor.
Okay. So if Rankin was the accomplice to Burbank and Collins, why isn't Rankin charged with murder?
That's not the state's argument. Their state's argument is Burbank and Collins were accomplices to Rankin's continued pressure on Mr. Ellis. And Officer Rankin's engaged in reckless conduct. And so the state should be able to argue that Burbank and Collins, being nearby, ready to assist, were accomplices to Officer Rankin's actions.
So in the state's formulation, is Officer Rankine then an accomplice to Burbank and Collins, but Burbank and Collins are not an accomplice to Rankine?
Well, we believe it goes vice versa, but the court has already made its ruling.
Well, that's what I'm asking you. If you think I'm wrong about that, you're then saying that
Correct.
Officer Rankine should have been.
It should
charged
go
with
the
murder.
other way as well. I think that all three of
But
them.
you're saying he should have been charged with murder.
No, with manslaughter, as far as reckless conduct, Officer Rankin and Burbank and Collins, all three of them restrained Mr. Ellis in a prone position, and that's reckless conduct based on their training and based on their knowledge that Mr. Ellis has said, "I can't breathe."
Okay. Comments from council?
Your Honor, there's the language about being just mere presence, and that's basically what we're saying, is that because Officer Burbank was there, he therefore is accomplice to Rankin.
Well, he's not saying that. I mean, he's saying he was there, sure. So are the other officers.
Surely.
But he's also saying that Rankine participated.
Well, he participated after Burbank was done participating. So that's the separation we have.
Well,
I mean, the instruction is
Yeah.
written, I think it's broken.
well, I'm not sure that's the legal distinction here, but okay.
Well, Judge, to be an accomplice, he's got to be an accomplice to the crime, right? And so what I hear Mr. Liu saying is, my client is an accomplice to
Reckless conduct, which is a substantial disregard from, and risk of death from that should be expected. I'm not sure how you can be an accomplice to something that's reckless disregard in that manner. It doesn't, they want to suggest it's a one-way street. Accomplice liability goes both ways, right? Officer Collins has.
That's why I asked him the question about
Right.
should Rankine be charged with murder?
Well, if you accept the state's theory, why is he not? Because he's necessarily an accomplice to my client, which doesn't make any sense. And so I think they recognize the shortcomings based on my client being an accomplice to the crime of manslaughter, I guess under this theory, through reckless conduct. It doesn't fit. There's
So then he would be an accomplice to manslaughter by Burbank or Collins, or both,
Right.
but not an accomplice to second-degree murder.
I guess that's their theory.
That's what it sounds like. He's nodding his head yes.
It doesn't make any
Lewis.
sense. But beside that,
I'm wondering about the logic of that, too.
yeah. And Mr. Liu suggests that the mere presence of my client alone somehow makes him an accomplice to this reckless conduct. The court need only look at the record. There's no indication that my client is anywhere near other than behind the vehicle or speaking to Sergeant Lim after he's relieved. So what aid or facilitation is coming from Officer Collins that would show that he was an accomplice to the crime of manslaughter, if you believe the state's theory of the case as it relates to the separate conduct of Officer Rankin? None. It just doesn't fit. And so I think the court got it right. The instruction's appropriate. Thank you, Judge.
Okay. Mr. Conrad or Ms. Bremner?
I mean, I echo what Mr. Osser says, that you can't have it go one way. And the state skips over the initial requirement, which is that the knowledge aspect of it, that they know that they're participating in a crime. There's absolutely no evidence of that. That's why it wasn't charged. The prosecution doesn't have a good faith basis to charge our client with murder too, because there's no facts to support it whatsoever. So to say that it's just a one-way street of accomplice liability, I think isn't logical given not only the instruction that's before us, but just the case law that supports it as well. And so I think the court's made the right ruling, especially given the evidence that's presented, and I think that the proof is in the pudding, which is the fact that the state hasn't charged because they can't. They don't have a good faith basis to do that.
Okay, well, the definition, which no one is disputing, is that a person is an accomplice in the commission of a crime if with knowledge that it will promote or facilitate the commission of the crime, he or she does various things. So that means that in order for a person to be an accomplice, you need to know that the crime's going on. And then, knowing that, you do something to promote it. Here, there's absolutely no evidence whatsoever that Rankine knew of any kind of criminal intent on the part of Burbank or Collins when he arrived at the scene. And the state's theory here is that Burbank and Collins had a intent to commit a crime upon Mr. Ellis that turned into Mr. Ellis's death. That's why we have second-degree murder. The fact that Officer Rankine enters in upon all this after it's commenced makes it impossible that Rankine could have been any part of the initial plan, if you will, if that's what it is, the state's theory, about what Rankine and Collins were doing. So he could not have been acting with knowledge that it would promote or facilitate the commission of the crime Burbank and Collins had formulated as to Mr. Ellis. So he can't be an accomplice. And the same is true of all the other defendants. All the other officers who were not charged. If at the time if the time Burbank and Collins had stepped away from any physical contact with Mr. Ellis, which we know occurred within a very short time after the hobbles were placed on him. And it could be that one of the officers would already had disengaged from touching Mr. Ellis. But if at that point in time everything had stopped and Mr. Ellis had been placed in the recovery position or whatever, and yet he had died, what would the argument be that Burbank and Collins were promoting the misconduct by Mr. Rankine? Because there wouldn't have been any misconduct by Mr. Rankine, right? So presumably Rankine wouldn't have been charged, but then you have to say, well, okay, but that isn't how it happened. Mr. Rankine was there, and Mr. Ellis was not placed in the recovery position the entire time until medical aid arrived. At what point in that continuum of time do Collins and Burbank recognize that what Rankine has done is reckless conduct? I don't know if there's any evidence at all about that. And there's not even any evidence as to much of what they viewed of what Mr. Rankine was doing. So I don't know how that would work. And of course, they would have to be recognizing that for them to be encouraging or promoting or facilitating the commission of Rankine's crime of, let's say, manslaughter in the first degree or second degree, they would have to be doing something to encourage it and not merely present. They have to be present and ready to assist, I suppose, in aiding the commission of the crime, but it's not sure they would, if they thought it was a problem, that they would have thought it was, then maybe they would have thought it was a crime, maybe they wouldn't have. As the instruction goes on, the law is that more than mere presence and knowledge of the criminal activity of another must be shown to establish that a person present is an accomplice. I mean, I just don't see how it fits. So I'll decline to change proposed instruction 23. Any other exception to the court's proposed instructions from the state?
Yes, Your Honor.
Yes, Your Honor. The state takes exception to instruction 25. So instruction 25 is an instruction defining intervening or superseding cause for purposes of establishing proximate cause, which is discussed in instruction 24.
Just so we're clear, I believe this is an accurate, unmodified WIPIC, right?
That's correct, Your Honor.
So the objection is whether we give it at all, just on the basis of the facts of the case.
No, Your Honor. So the state objects actually to the exclusion of the third bracketed paragraph of the
Oh, you'd like the other paragraph?
Yes,
Okay.
that's right.
Okay, continue.
And that third paragraph reads, quote,
What's the WIPIC number again?
the WIPIC number is 25.03.
Thank you. Go ahead.
And that paragraph explains that, quote, if in the exercise of ordinary care, the defendant should have reasonably anticipated the intervening cause, that cause does not supersede defendant's original acts, and defendant's acts are a proximate cause. It is not necessary that the sequence of events or the particular injury be foreseeable. it is only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. And the reason that we're asking for this language to be included in the instruction is, I know when we discussed this at our conference, maybe on Friday or Thursday, we talked about some of the potential superseding or intervening causes that the jurors might be considering.
Yeah, I think I specifically asked each of you, what intervening causes are we talking about? The methamphetamine, the heart, anything else,
That's right.
right? Nobody said anything beyond those two.
Well, one of the other causes that we mentioned, Your Honor, is the actions of other officers on the scene, and specifically the actions of Defendant Rankin and the actions of the officer who placed the spit hood on Mr. Ellis. And it's the state's position that the general field of danger language is relevant to the jurors. If, for example, the defense argues in closing that somehow defendants would not have reasonably anticipated or could not have reasonably anticipated those actions of other officers, if they made that argument, then it would be imperative for the jury to have this bracketed language to assess whether or not they agree that those actions of other officers are not reasonably foreseeable. And this is because in all, the case law is pretty clear that in all but the most extraordinary cases, issues of cause and fact and the issue of whether there is an intervening or superseding cause are exclusively jury determinations. And so we think on the possibility that the defense may argue that, we would ask that the jury be instructed so that they can evaluate.
Can't you argue that from the second paragraph that we've got here already?
Well, I think the second paragraph gives some basis for the jurors to assess, but what it doesn't do is it doesn't define in much detail what reasonably foreseeable means. Paragraph 3 is much more specific to describing how the jurors should evaluate that term.
Well, it's just sort of the flip of paragraph 2, right?
We agree that it's not inconsistent with paragraph 2. We just think it's a helpful elaboration on the standard, and it also
I wish you guys
clarifies-
would have said this last week. I tend to have some sympathy for what you're saying. But you didn't say this last week. But that's no reason not to make the change. I just wish you'd done it. I'm not sure it's necessary to do this, but I'm not sure it's bad. Mr. Osler?
Because that's not why the court struck paragraph 3.
Well, no, because this wasn't discussed. I asked, is there another cause, and they didn't mention the other officer potentially.
Right, and the discussion was in context to accomplice liability. And because the court found there wasn't accomplice liability, that wasn't pertinent to this instruction as a drafted material.
No, that was your argument. That wasn't my thinking on it. My thinking was, look, because if Burbank and Collins can only be liable for what happened after they stepped away from Mr. Ellis, based on the idea that they're an accomplice to Rankin, I said, which was kind of your theory, which is kind of what you're telling me now, I'm saying, no, that's not true. If what Rankin and the other officers did was reasonably foreseeable, then that could be that could be just a continuation of what happened. And I gave you my example of course, the guy had been beat up, and then medical negligence later on was contributed to the death of the person who had been severely beaten. The persons who severely beat that person were liable for his death, because the idea there is that medical negligence was foreseeable. And so even if you say Rankin's actions were not reckless or in furtherance, he wasn't an accomplice because it wasn't in furtherance of anything Rankin or Collins were trying to accomplish. And maybe they weren't criminal of themselves, but maybe they were negligent. And that of the officers too, they could still say that that's a foreseeable consequence of your conduct in putting Mr. Ellis in this predicament in the first place. So that's why they're still in the case.
Right, if you recall, Judge, that you asked specifically of each of the parties, what are the intervening superseding causes?
Well, I did.
And the only response from the state was methamphetamine and the heart condition.
Well, yeah.
Which don't come into play in paragraph 3, so the court excluded that inappropriately.
Well, yeah, because the idea there is that what's a super, really, the paragraph 3 is not it's not necessary for the state to argue that paragraph 2 does not apply and therefore there's no supervening cause. It is nothing more than a different way of looking at it and a further elaboration of what is not a supervening cause. So the paragraph 2 defines what is a supervening cause, and presumably if this isn't one, then it's not a supervening cause. Paragraph 3 is, this is not a supervening cause. And they're really not far apart.
Right.
But there's no reason not to necessarily give the third one.
Right, and I think it's, the question is this instruction infirm? And my response is no, because paragraph 3 is bracketed material, and paragraph 2 allows the state to argue its theory as it just described in court. So this is accurate and allows the parties to argue from it appropriately.
Well, the idea on the note on use that we have here from the Committee on Washington Pattern Jury Instructions says, use the bracketed third paragraph only when there is an issue whether the resultant harm falls within the general field of danger that should have been foreseen. It does. That's why I wish they'd said something better in their arguments over Thursday and Friday. Or probably would have left it in. Because when we're talking about what is a supervening cause, this is not. The actions of the officers is not a supervening cause. They're not. But it may well be argued that those actions were a cause or a contributed thing, and the question is whether or not that should be attributable to Collins and Burbank, certainly not to Rankine. If it is foreseeable, and that's what I've said repeatedly, and this paragraph makes clear, I don't think it's necessary for the state to argue that those things are not intervening causes, but it may clarify for the jury that they could be. So, have you got a clean version with this third paragraph included?
We do.
Yes, we do.
Please provide it, and I'll
Well, Judge, I
include it.
think they can argue that, as you've already said. by
They can.
instruction,
They can.
But there's not a need to add additional paragraphs.
It's not necessary, but it's reasonable. So I'll give it. Let's see.
Is that instruction 25, Judge?
It would be 25. Yeah, have you guys got, yeah, he's handing you copies now. This is when I'd say, put the number 25 on that. And then we'll substitute that in for the other 25. So I'll accept that exception. You're gonna need that for that one. Yep.
I'm gonna need some time to rework some of my, I mean, my understanding of the discussion with regard to this about the prevention from the heart condition.
Yeah. This doesn't say that those, you're not, they're simply saying that the officers, the actions of other officers who appeared at the event are not supervening causes. And you're not really saying they're supervening causes either. You're not saying, look, we're not responsible because who screwed up with these other officers? They're the ones who are responsible. Maybe you're gonna say that about whoever put the split on. I don't know what you're gonna say. But your argument is, no, the methamphetamine and his heart condition causes death. Those things were not caused by anything we did, and there was nothing we could anticipate or do anything about. So you can still argue that. I don't see what the issue is.
I mean, I don't see how, I mean, the instructions are that the defendant's conduct was reckless or criminally negligent, so I don't see how the state can argue, you know, I mean, that's all you have to do.
Well, I suppose if they argue something you don't see how they could argue, you'll be able to point that out with clarity to the jury, and you'll prevail. If you can't, you won't. So that's how this works. All right, so any other exceptions to the court's proposed instructions from this day?
Yes, Your Honor, just one more. Instruction number 32. And so just to be clear at the outset, the state is not taking exception to giving this instruction generally.
Let's see.
I think as we discussed at some length during our conferences, the State v. Brightman and State v. Slaughter cases essentially say if a defendant claims to have been lawfully authorized to use non-deadly force and unintentionally or accidentally kills someone in attempting to use that level of force, that defendant has an excusable homicide defense, but not a justifiable homicide defense. And so the state agrees that giving this instruction, which is a version of WIPIC 17.01, is appropriate here. The state only takes exception to the form of the instruction, and specifically the first and final paragraphs of the instruction.
You said, okay, go ahead.
Yeah, and so
So there's 3 paragraphs, and your only objection is to 2 of them.
2 of them, yeah, right. And so, but our objection to the first paragraph is simply to the phrase, "It is a defense to murder or manslaughter that." And then I'll say our other one and then explain. Our other exception is to just the final paragraph in its entirety. And
What, the burden of proof is on you?
that's right.
Well, if somebody is using lawful force, the state has to prove the absence of the use of lawful force.
Yes, that's right. And so, and that's what the excusable homicide instruction, instruction number 33, already instructs the jurors. It instructs the jurors that a lawful act by lawful means is a component of the excusable homicide defense that the state needs to prove beyond a reasonable doubt. Our concern about the addition of this language into instruction 32 is that it might suggest to the
32?
jurors.
32?
Yes, in 32. It might suggest to the jurors or be confusing to the jurors as to whether the defendants have a separate, something equivalent to a justifiable homicide defense, I guess, based on 17.01. And whether this 17.01 description is separate from the excusable homicide. And it's the state's position that removing that language and simply describing what use of force would be lawful using the same standard from 17.01 would be more clear to the jury in terms of how to categorize that. It would fall within that excusable homicide, lawful act by lawful means language. And yeah, I think that's it.
Okay. Defense want to comment?
Your Honor, this one is specific to police officers in regard to the conduct that they engage in. So it is appropriate for the court to give this particular instruction. It talks about officers in their line of duty, what they face, and how they handle the specific in this particular instruction. The other instruction is more of a general instruction, but it's also appropriate talking about excusable homicide. So both of these instructions are appropriate.
Mr. Usher?
Judge, this is accurate state of the law. For instance.
Right, in a way that the state's arguing this is redundant with excusable neglect. A little bit, they're kind of saying that.
Well, except for the court knows an assault is an unlawful act, right? And this is saying it's actually lawful, and the state has to disprove that because it's an element. And so this explains to the jury what the state must do in order to meet its burden as it relates to assault, 3, assault 2, unlawful imprisonment as a predicate felonies. This is an element, and they have to disprove that beyond a reasonable doubt for Mr. Collins to be criminally liable. And so this is the law. It's accurate, and the court should get it.
Mr. Conrad, any comment?
I think it would be error not to give it. I think that it applies, all paragraphs apply, and I think the state's acknowledged that. So I don't know why we would risk issues on appeal by spraying domestically. I think that we went through this exercise over the course of 2 days. I think we came to a right decision.
I have to say, though, I am thinking about changing it one more time, but not eliminating it. I'm just wondering, in a way, this instruction goes to talk about the use of force in regard to the predicate felony offenses for the murder too. You know, that it's, we've already defined that it's, that when an arrest is lawful and that they may use necessary force to effect an arrest. I suppose maybe what I should do with respect to instruction 32 is add the language, it is offense to a charge of assault, murder or manslaughter, or murder or manslaughter or assault, or murder or manslaughter, assault, or unlawful imprisonment. Since those are the predicate offenses here. That the use of the force was lawful.
Judge, that'd be fine.
What? I'm surprised. It makes it harder for the state. I mean, that's one the state wouldn't like, I suppose. But I do see this as different from 33 because even though there's similarity, it says in 33, homicide is excusable when committed by accident or misfortune in doing any lawful act by lawful means, without criminal negligence and without any unlawful intent. And one could well make the argument, well, that's all you need to show from the defendant's point of view, and that should be sufficient. But it's a little bit like the one we just changed, I suppose, that this is another way of looking at it, and it applies to at least the other offenses too. We talk about when homicide is excusable, we don't talk about when assault is excusable. But assault is not an assault if the force that was used is lawful. Usually we think about lawful force being used in an assault matter when you're acting in self-defense. Then you can use a reasonable amount of force to protect yourself. Here, we're not talking about self-defense, though. We're talking about the authority of police officers to use force, violence, if you will, to arrest somebody. And so I'm thinking 32 maybe should be charged as a defense of a charge of murder, manslaughter, assault, or unlawful imprisonment. What do you think?
Well, Judge, that's exactly what I was going to argue in my foot. I mean, it applies to predicate felonies as it does to the substantive charges. If you want to add the language, it makes it more accurate.
You were going to argue that?
Absolutely going to argue that.
Hold on a second. So that means you already have an instruction that says this?
No. That instruction applies.
I was hoping for too much.
No, but arguably that instruction applies just like the court said. And so I was prepared to argue that applies to both the underlying predicates, which is
Right.
why, Judge, I offered 1701 separate as it related to this predicate. I know we've gotten to my objection yet.
Well, yeah.
But I offered that same instruction.
The problem was, of course, you also offered 1602,
Correct.
which doesn't quite work.
I know.
Well, so does your 1702 say what I just, or your 1701 say rather, just what I said?
It went on to the predicate offenses. I offered two separate, right?
Yeah, it didn't go to all four.
I had one for the murder manslaughter, and then one for the predicate offenses.
Well, maybe that would solve the state's concern too. Maybe if I just put it as to the assault and the unlawful imprisonment, then the homicide charges would be excusable under 33, under instruction 33.
Well, except for this instruction also applies to the manslaughter, so I think you'd be separating that out. I think that would not be accurate.
All right, so can one of you get me an instruction that says it is a defense to a charge of murder, comma, manslaughter, comma, assault, or unlawful imprisonment, et cetera, et cetera? If you do, I'm willing to do that, but I'm not willing to remove it as the state has urged. as I say, it serves a somewhat different purpose and is, I think, necessary.
Mr. Conrad, preparing that.
Okay. So that's going to be the ruling as to 32. Any other exceptions by the state to the court's proposed instruction?
Nothing further.
Okay, thank you. Mr. Pertzer, any exception to the court's failure to give a proposed instruction by defendant Burbank?
Yes, Your Honor. I take exception to the court's decision not to give Mr. Arthur Burbank's instruction number 8, the assault definition in the final paragraph, which states that an act is not an assault.
Hold on. Let me find it. Your proposed number 8?
Yes.
Oh, all right. How does that compare to the one we're giving?
Your Honor, the difference is that you did not include the final paragraph that of consent. That an act of assault, or an act of non-assault is done with the consent of the person.
Oh, that's right. Okay.
It's our position that Mr. Ellis, by resisting, is consenting to be assaulted by the police officer based on his conduct.
That's a very broad and imaginative definition of consent, I think.
Well, indeed, but it's respectful to the clients.
Okay, fair enough. Any additional comment from the other defendants?
No, thank you.
Ms. Conrad?
Okay.
Mr. Liu, I don't think you need to argue this one. I don't think that is correct in terms of the facts of this case. Certainly, one can consent to a fight like a prize fighter does. That's not what happened here. So, I won't give it. Any other exception to the court's failure to give a proposed defense instruction?
Go ahead.
Any exception to the court's proposed instructions?
Yes, Your Honor. There is with respect to the crime of murder in second degree, object to take exception to the court including within that paragraph B, assault in the third degree, because believe that the assault in the third degree is contained within assault second and also the unlawful prison based on the simple fact that the case was used that did not in any fashion rise to the level that would cause Mr. Ellis' death. The balance of my objection would be to that same language in the various instructions.
Let me find it here. But the argument there is that that the use of a taser, for instance, was not a proximate cause of the death of Mr. Ellis. And it may well be that that's the case. But in any case where there is, for instance, an assault, and again, as my case with the person who was beat up and then died from the medical negligence that occurred later, one could argue that the medical negligence was the true cause of death and not the assault by the defendant on the victim there. But it's for the jury to determine that. And so you have instruction number 24, the court's proposed 24, which instructs the jury, and which you may argue about, I'm sure, to constitute murder or manslaughter, there must be a causal connection between the criminal conduct of a defendant and the death of a human being, such that the defendant's act or omission was a proximate cause of the resulting death. And it isn't enough to say that the logic of it is, well, for me to jump from the fact that there was an assault to that didn't cause it and let the jury decide, as opposed to letting the jury decide it and there was an assault. And so I can't take assault 3 out.
Well, I agree that there's facts to suggest that there's assault, and the assault 2 includes within that anything but assault 3. So that's the basis of the objection.
Yeah. I gotcha. Really, the argument is the facts of the case don't support assault 3.
Agreed, totally.
Okay. Gotcha.
So-
Okay.
And Judge, following in line with that, would object to the assault instruction number 18, which defines.
Well, I got to do one of these things at a time. So you're complaining about the assault definition not being given your proposed, I'm sorry, take that all back. There was your, what was the other, I'm sorry, what was the other instruction? Oh, the
court's instruction.
All right, so you're no, so my question to you was, are there, and we'll get to that, but my question to you is there any other exception to the court's failure to give us the proposed dissent? Okay. So as to the court's proposed instructions, you have, your objection is to which instruction?
Number 9.
The court's number 9.
Yes. Court's number 9.
Okay. And you're saying that should be amended to remove the middle, the subparagraph B.
That's correct, Judge.
Okay. Any other comment from the defense? Anything else you want to add?
Well, I've got other instructions. but nothing-
No, but just on this instruction. Anything else anybody want to add?
Well, on a separate basis when we talked about mine, Judge, so.
Okay.
I'm happy to add to Mr. Purzer's exception.
Got it. Mr. Conrad?
No, Judge.
Okay. State care to comment?
Nothing further from
Okay.
nothing further from, other than what the court has already determined.
Yeah, as I say, I think assault 3 sort of pushes the envelope here, given the comments of the various concurring Supreme Court justices in the State versus Gamble case that we have talked about from 2006, I believe. But be that as it may, I think the facts at least permit this to be considered by the jury. So I'll adhere to number 9.
Judge, court's instruction number 18 is the definition of assault in the 3rd degree, and we again object to having that included in its entirety.
I'm sorry, that was number 18?
Yes,
Just which is a corollary to all this.
correct.
So yeah, I'll adhere to 18 as well.
Judge, number 19 is the definition of assault in 3rd degree with respect to both Officer Burbank and Collins. But again, we'll object based on his prior arguments.
Right, and for the same reason, 19 will stay.
And then, Judge, with respect to instruction number 34, the to-convict instruction, again, object to assault in the 3rd degree being included in that to-convict instruction.
Okay. Same ruling.
And then instruction number 41, which is the lesser included instruction for manslaughter in the 2nd degree, would object to the inclusion of manslaughter in the 2nd degree factually. Understand that legally it's appropriate, but factually would urge that it does not apply.
Well, it seems that if there was a factual basis for manslaughter 1, there'd be a factual basis for manslaughter 2. And I'm satisfied there is such a factual basis, so I'll adhere to 41.
All right, and then, Judge, instruction number 42 is the definition of manslaughter in the 2nd degree. Would you object to that?
For the same reason, I take it.
Yes, sir.
Okay. Mhm. Okay, I'll adhere to giving 41 and 42.
Thank you, Judge. And then instruction number 43, which is just defining manslaughter in the 2nd degree.
Well, 43 gets you to the lesser included,
Correct.
right, so, of manslaughter 2.
Correct.
So really, wait a minute, is this in here twice? Oh, no, I understand. Okay, it's just essentially the negligence definition. Okay, go ahead. So you're saying, well, you're basically saying the entire suite of instructions as to manslaughter 2 shouldn't be given. So
That's correct.
that would include number 43.
That's correct.
And what else?
And then also number 44, which is the instructions for Officer Burbank on manslaughter and second degree.
Gotcha. Yeah. And since I'm deciding all of that's in, then that's fine.
And then finally, the verdict form B for count 2 for Officer Burbank and manslaughter and second degree.
So the corresponding jury verdict.
Correct.
Okay. Okay, I'll adhere to all that nonetheless.
And that's it. Thank you.
Okay, thank you. Mr. Osser, any exception to the court's failure to give a proposed defense instruction?
Yeah, so go through my packet first, Judge, what you're asking today to give my proposed.
Yep.
I'll start with jury instruction number 8. And in my pattern instruction 2703, I include or justifiable. The court declined to give the justifiable instruction.
Right.
And in your packet of instructions, you limit it to excusable. I think it should include justifiable, and if not justifiable, then at least lawful. And so I understand the court's ruling on that, but I take it, object to not getting my version of 2703.
Judge, Officer Burbank made the arguments related to the justifiable, denial of the court to give the justifiable instructions.
Judge, you want me to make all the arguments about justifiable, because I'm going to be objecting to the corollary instructions that define justifiable as relates to the court not giving it in instruction number 8.
Sure,
So you do it once instead of 12 times.
fine.
Um,
So it's your number 8?
That's number 8, Judge. And then my instruction 25, Judge, which was pattern instruction 1601 that defines.
I'm sorry, what's your number again?
25, Judge.
25, okay.
And that's pattern instruction 1601, that lengthy dialogue about the application of this. I propose this instruction because it applies specifically to use of force by a law enforcement officer charged with murder or manslaughter. And it defines the circumstances through which the conduct of an officer would be justifiable in a separate defense from excuse and failure to prove lawfulness. I think this is an appropriate instruction, and I know that we had extensive dialogue about the uniqueness of this case and how this would apply in these circumstances.
The facts don't quite fit what I imagine was in the minds of the people writing this instruction at the time.
Right, and I think the court ultimately concluded that deadly force is not used, therefore this is not really applicable, and I just disagree. I think this is a lawful defense, justifiable defense that the state must disprove, and so that goes in line with jury instruction number 8. Then my jury instruction number 35, Judge, is pattern instruction 1602. Again, this, I believe, is a separate and distinct defense from excusable homicide. I think it's applicable to both murder and manslaughter. And I think provides a separate basis for a jury to determine the state failed to disprove this defense beyond a reasonable doubt, and the court should give that instruction.
Anything else in this vein?
No, I think one more, Judge.
Okay.
My proposed instruction 37, which is pattern instruction 1603. It talks about it being justifiable use of force by any individual who's resistant to the commission of a felony, and that they employ such force as a reasonable person would in the same context. I think, again, that is separate and distinct from excusable. It's applicable, and it should be given in this case. On the same side, we did a variation of 1702, which is pattern, my proposed 38, which addresses specifically the underlying felonies, and I think the court included the language that we just discussed, one of the state's objections that would incorporate this, but again, I think this is a separate instruction as to justification as it relates to the underlying predicate felonies. It should be given separate and distinct from as a defense to murder and manslaughter. So,
Well, once we give the one I've changed, that's tantamount to giving this one.
it is, the essence of this is incorporated in what the court has just modified. I agree with the court. But I propose this separate instruction, and say that you have no objection. And so those all go to my justifiable and or lawful as it relates to instruction. So what was addressed those first, and I'll move on to others.
Yes. Any comment from the state?
Yes, Your Honor. So the state agrees with the court's instructions here, and specifically not instructing on justifiable homicide. So two of the cases that the state focused on in briefing these issues were State v. Brightman and State v. Slaughter. And so, if I could find it. So from State v. Brightman, that's 155 Washington 2nd, 506. And it's a 2005 case. And so at page 525, the Supreme Court there said, quote, while a defendant may take actions in self-defense that lead to an accidental homicide, one cannot actually kill by accident and claim that the homicide was justifiable. The proper defense for an accidental homicide is to argue that the homicide was excusable. Similarly, State v. Slaughter, that's 143 Washington App, 936, that's a 2008 case, at page 942. The court there said, quote, in a case where a defendant does something in self-defense that leads to an accidental homicide, the applicable defense is excusable, not justifiable homicide. So I think those cases summarize it pretty well. And the way that those cases use the term accidental, as I think the court alluded to during our various conferences about this, it really means an unintentional killing. And so here where there is an act of self-defense that's claimed to be lawful, but that is not an intentional use of deadly force, not an intentional killing, an excusable, instructing the jury on excusable homicide, and then instructing the jury on the definition, essentially, of what lawful force is in that context is appropriate. That's what the courts did in the Slaughter and Brightman cases. And to just take an example from the Brightman case, that's a case where the court may recall the defendant in that case was engaged in somebody he claimed was trying to rob him. They're engaged in an altercation. He took out his gun to hit the person. He claimed in lawful self-defense to basically an assault. His gun accidentally, he claimed, went off and shot the person. And so that actually illustrates pretty well this concept of while that defendant may have had an argument that he was lawfully able to use his gun to hit the other person. Once the gun, when the gun unintentionally goes off, that doesn't then rise to the level of justifiable homicide, and it's not appropriate to view it under that circumstance. Yeah, so that's the basis for why the court is correct not to give those instructions.
And for
In
the,
response to that, this case is very different. We're talking about police officers using justifiable force versus a Brighton in the other cases, it's not. And quite frankly, 1602 deals directly with law enforcement officers exercising their official duties. And so this case is very different, and I think that's what the court and party struggled with for some time on Thursday and Friday, is crafting instructions that are specific to this case. And I think 1602 and the justifiable nature of it are appropriate. I think, as Supreme Courts have constantly held, is this is a separate and distinct defense from excuse. And a juror could very well find it was justifiable as opposed to unintended consequence. They're not mutually exclusive, so I think they should both be given consideration.
well, and that's why I've given something like your 37, we're now making the changes to, because it is separate and apart, I think, from excusable, which I said before, when we were talking about that issue, that there's a little something different in the case which doesn't quite touch on excusable here. But the problem is that this case is, and so referring to your proposed number 8, the reason why you use justifiable is mostly based on the idea that I'm not giving you 25 and 35. And the reason I'm not doing that is because the idea of those instructions has to do when deadly force is being used. In 16.02, it talks about the circumstances under which homicide or the use of deadly force is justified or justifiable. And of course, deadly force may or may not produce death. So the question is because it's a kind of force that may produce death. Whereas homicide, in fact, obviously produced a death. But the idea there is that the force that was used was done with some intent. And here the oddball thing about this case is we have police officers who were dealing with, in this case, Mr. Ellis, in such a manner that it results in, at least the state's argument is that they improperly were trying to arrest him or assault him, and the result was his death. But the state is, if the state was claiming that they intentionally killed him, they would have charged a different offense. They're not saying that. So that's where we get to this assault in the second degree business. And what was unusual about this too is that the force that was used by Burbank and Collins, when they quit using force, that force of itself was not deadly force. And it didn't produce his death, not directly in that sense, or at least not immediately. The argument is that the subsequent care of Mr. Ellis resulted in his positional asphyxia, and that caused his death. And the argument is that Burbank and Collins should have foreseen that as a reasonable consequence of what they were doing. And that's why we have second-degree assault, second-degree murder here. But the force used there was not homicide, and it wasn't deadly force. So the facts of this case, as I say, normally when someone's killed in such a circumstance, it's because we meant to shoot somebody, and that resulted in their death, and this kind of instruction would have been given. That's not what happened here. So I didn't think that 1602 was right, and that's what sort of defines justifiable in this circumstance. Usually think of justifiable as being in self-defense, but we're also talking about legally authorized, and I suppose maybe it's a matter of semantics as to whether or not one says that homicide was justifiable or simply that the use of the force in this case was lawful, the result's the same from the defense point of view, assuming you persuade the jury. So, I will adhere to the giving of well, I think that given the instructions we have given, suggests that I should not give the defendant's proposed 8, 25, 35, or 37. But I am giving a modified version of 38, so I don't know that you really have a complaint now. As to that.
It's my job to complain.
Understood. Any exception to the court's proposed instructions?
I got a couple more objections on mine, Judge.
I'm sorry, go ahead.
In my proposed 11, it's pattern instruction 3510. That's the definition of assault in second degree. The court will recall.
Your number 11, did you say?
My 11, Judge.
Okay, go ahead.
The court will recall we had dialogue about the varying prongs of assault in second degree as it relates to the predicate felony. In count one, as it relates to Officer Collins.
Right.
State alleges substantial bodily harm, reckless infliction of substantial bodily harm. I don't think it's actual basis for that in this case. In fact, I think the only prong, as the court knows, multiple prongs under assault 2 that justify moving forward, and that the court agrees with. I also object to that, but the court's point is that strangulation is the only method under assault 2 which is viable based on the facts presented. And so I object to not giving my instruction 11 and take exception to the giving the corresponding one that the court gave, including substantial bodily harm.
Which I think amounts to instruction number 9 and the ones that are related to that.
And given the basis for that, the court knows, so there's a specific definition of substantial bodily harm. It's a temporary or substantial disfigurement. And in this case, I think the state argued bruising or a laceration to the forehead was sufficient for a jury to find that. I don't think that's an outline of facts in this case. So that's why I object to the failure to give my 11.
Yeah, there was also, of course, a very prominent abrasion to Mr. Ellis's face.
Reaction to his face as well.
Well, I guess I'm not going to allow this. Does any of the defendants have another argument about this? I mean, I understand the position. I do think that we have this, as I say, the complaint of the justices in the Gamble case, where in which the very same conduct which constitutes manslaughter could also be charged as murder in second degree, and the conduct is identical, and yet the penalties are very substantially different from each other. And that is a troubling thing. The legislature has not seen fit to make any changes to all of this. And so when you start getting from substantial bodily, or recklessly inflict substantial bodily harm element of assault in the second degree, and now to assault in the third degree, you're getting even in some sense farther and farther away from the idea of intentionally trying to kill somebody. But of course, intentionally trying to kill somebody is a different crime. Well, anyway, I do think there's evidence in the case sufficient to go to the jury and a reasonable trier of fact to find the elements of assault 2 or assault 3. And of course, assault 2 also can be committed by strangulation. And of course, you're proposing only the strangulation component here in your proposed number 11. Yeah. And we talk about it in our instruction number 9, the court's instruction number 9, which talks about assault 3, assault 2, and unlawful imprisonment. And of course, the accompanying instructions which define those terms further. Okay? So I will decline to give your 11.
Thank you. 17, and just for try to get through this quickly, I adopt all of Mr. Kurtz's arguments about assault 3 as it relates to predicate felony.
Okay.
But my 17 differed from the instruction that the court gave because the state had proposed varying alternative means that assault in the third degree could be committed. And I think primarily that causing substantial pain and suffering for a substantial amount of time, I think is some language. And I think that's not appropriate. And so I object to giving it that. I'm not giving my 17 would be a wonderful thing.
Okay. As I say, I'm giving it, so,
Understood.
Okay.
We need to make an objection to the court not giving my instruction 22. And I don't need to belabor this. I included the justifiable, the court did not, as it relates to
Right.
manslaughter. It's the same argument I made with count one.
mhm.
Judge, I also object to the court not giving Officer Collins proposed instruction 39. That's pattern instruction 1704. That I think goes in response to the modified 1701 that the court's approving. And that's that Officer Collins is entitled to act upon appearances and he can be mistaken about the extent of the actual danger in space.
Sure, the problem with 39, though, is, again, it is a self-defense type instruction, which means that the authority to use force is when one is acting on appearances and defending themselves. Here, there's no claim of an apparent assault by Mr. Ellis on folks, because you're claiming he in fact did assault them, at least among other things. So, and so because that they were arresting him, not defending themselves.
Well, I'm not admitting my client assaulted anybody.
Well, if the definition of the word assault means unlawful force, I understand that. If the word assault simply means you used violence, you put your hands on somebody, then in that measure, yes, there was an assault.
I agree.
But the legal definition of assault, by that, you're right. But that isn't how I meant it. Sorry if I led to confusion.
I understand. Those are my objections.
Okay.
And my exceptions to the court's instructions are just as outlined by Mr. Kurtzer, the same instructions, and the court giving of the instructions that don't include my justifiable and the lesser included. So I don't think I need to elaborate those objections. The court wants me to.
Not necessary.
Thank you.
Okay. So I've explained why I think justifiables, to some extent, it's a matter of semantics. I've decided that there's excusable in the case and there's lawful force in the case. You may call that justifiable if you like.
Thank you. That's all I have.
Okay, but it's not in the instructions as justifiable. And because I don't think it's necessary. Okay. I got to take Mr. Conrad's instructions. We need to take our morning recess this time. So we'll be at break for 15 minutes, ladies and gentlemen. Please do not discuss the case, everybody, if that's impossible. Nobody's given me to.
Judge, is that?
Well, this is another instruction.
No, the one you requested plus the additional that we had discussed previously.
Right. I just want the one I just instructed on, which was, this was in place of what, 20? 32? Yes.
Judge, I think to be consistent, we should say that it should read as a defense to charge of murder, manslaughter, assault in the second degree, assault in the third degree, or unlawful harassment.
Well, assault includes both.
That I understand. If I understand that, it just makes it consistent throughout the package we go with various offenses.
Well, no, I appreciate that, but this will work. So we need, it's 32, Susan. Yeah. And you've got it for your
There
packet.
you go, you've got to do it now.
Good. Okay, I think where we were left off was I think you'd completed yours, had you not, Mr. Hauser?
I did, thank you, Judge.
Okay. We were at, that was now the exceptions to the instructions by Officer Rankine, dependent number 3. Mr. Conrad, any exception to the court's failure to give a proposed defense instruction?
Judge, I think exception to the court not giving the instruction 1602 for justifiable homicide,
Hold on a
defense
second.
of self and others.
Which proposed instruction was that of yours?
It was proposed, I believe, during discussions of the instructions. I'm not sure I actually included that within my packet because I believe it was included with someone else's.
Well,
Right.
It was in mine, Judge.
so you're objecting to me not giving an instruction that was proposed by Officer Collins? So, which number was that of Officer
That's
Collins?
one way to put it. I could offer it myself as well, but it was being offered already by the defendant.
Which number was it for Officer Collins?
I don't have that packet in front of me right now.
Right here.
35,
Okay, and we've had that discussion,
we have.
okay. Any other exceptions to the court's failure to give a proposed defense instruction?
Let me check my notes real quick, Judge. I don't think I have anything else.
Yes, we do. Number 10, we don't want the final more than one cause.
Sure. Instruction 10 under our packet.
We don't want to have more than one cause. Okay.
The court currently has the last bracketed information in there. We take exception to that.
Well, that's a little different, but okay.
And then
That is,
I don't know about that. It's mistaken belief, and it's a mistaken belief. It really applies.
Okay, that's the court's 24. And you're saying that the language of there may be more than one proximate cause of death has been added to the court's, but it was omitted in yours, and I should have done that. Is that what you're saying?
Correct.
Okay. Well, it's a correct statement of the law, and I think the facts support the possibility. So I'll adhere to the court's 24 and not the defense 10. Any other exceptions to the court's failure to give a proposed defense instruction?
We just offered the instruction that we had previously discussed about relying upon hearsay information,
Oh.
or experts relying upon hearsay information.
Hold on a second. Yeah, we don't have a number for this. You had proposed instruction last week where you said, well, here's the instruction you're offering this morning. Have you got this, Mr. Lowe?
We do.
Okay. It says, during this trial, you have heard the opinions of expert witnesses. To explain their opinions, those experts have testified to information such as non-defendant officer statements that they relied upon in forming their opinions. That underlying information is not substantive evidence and cannot be used to support a necessary element of the crimes charged. Again, some of that underlying information was in fact substantive, so it's not clear what they can count, include, and not include. We did give them a special instruction during the course of the trial about how to use certain evidence, and we could have done that with respect to other items too, conceivably. But I think this is over-inclusive still, so I'll not give this instruction. Any other exceptions to the court's failure to give a proposed defense instruction?
Nothing that I can think of.
Any exception to the court's proposed instructions?
The board just changed the instruction on the superseding, agreement with objection to inclusion of the last paragraph.
I'm sorry, what's that?
The inclusion of the last paragraph on superseding.
Right.
I'll note our objection to that.
Okay, I've already explained my reasons for that.
You have.
Here to that.
No lesser.
And we'll note our objection to the lesser included manslaughter.
I'm sorry, I'm having a hard.
Sorry. I don't know if it's actually been offered by the state at this point. But
What's that?
there hasn't been any motion to amend the complaint
Information.
at any point, the information at any point.
Well, manslaughter 2 is not offered as an amended information. It's offered as a lesser included of the original information, which is manslaughter 1. They don't have to amend the information for that. For instance, they had to include manslaughter 1 with respect to Burbank and Collins because manslaughter 1 is not a lesser included of murder in the second degree. But manslaughter 2 is a lesser included of manslaughter 1, which they did charge. So it's offered as a lesser included as to counts, count number 2 is to Collins and Burbank, and the only count that Rankine was charged with. So it's a lesser as to his count 1.
Understood. I'll just note our objection.
Okay, well, if I did it any other way, I would have a problem. I mean, the argument may well be, and it's been made here by Mr. Pertzer, and I guess joined in by Mr. Osser, that there's not a factual basis for assault, for manslaughter in the second degree. Everybody seems to agree, although maybe I should now caveat that you might not agree, but everybody else seems to agree that manslaughter 2 is at least legally a lesser included of manslaughter 1. And everybody, I think, also agreed manslaughter 1 is not a legal lesser of murder in the second degree. As I say, it was charged that way, and in the alternative, if you will. They didn't say in the alternative, but we had a discussion about what would the significance be if somehow Collins and Burbank got convicted of both murder 2 and manslaughter. And as I understand it, the legal significance of that would be that the manslaughter charges would go out. They'd only be convicted of the most serious one as an operation of law. But the jury could find both. So, anything else?
Nothing else, Judge.
Okay. So we have the new 25, I guess it was. It was 32, I guess it was. And with that, I think we've got our set. So I'm going to ask, we're going to take a break at least long enough for Mrs. Winnie to make copies of all this stuff, which could take a while. And because we have to make at least 16 copies for them. I think we need to make one other, 14, that's right, because we lost 2 jurors. You have to make one more for our court administrator.
Yeah.
And there's anything else you want to add, Mr. Conrad?
Well, Judge, I did have those motions that I filed as well.
Oh, well, we can, I suppose we could talk about that. You had motions in limine with respect to the state's closing arguments. Sure. Do you want to be around for the motions in limine? If you don't feel like you're necessary, you can go.
No, I'll just indicate I'm not.
Okay, so you can go try to copy those things. You know, I'm not sure we're going to get to reading these things till before noon anyway, but we'll see. Okay, motions in limine regarding closing arguments. The first one was, by the way, you got a copy of all this last week, right?
We do.
Okay. Motion to prohibit the state from making policy-related arguments. And elaborating, it says prosecutor may not urge jurors to convict a criminal defendant in order to protect community values, preserve civil order, or deter future lawbreaking, citing the case of State versus Ramos, 164 Washington App 327 at 338, a 2011 case.
State is not intending to make any type of those arguments, Your Honor.
So I can grant that one?
Yes, Your Honor.
Okay. Motion to prohibit any argument or suggestion that the defendants or any uncharged officers are colluding or covering for each other, or any thin blue line type of argument.
State is not making any such arguments, Your Honor.
All right, so you have no objection to me granting that?
No, Your Honor.
Motion to prohibit the state from making sympathy arguments.
State will not be making such arguments, Your Honor.
Okay. If they describe his death as tragic, is that a sympathy appeal, Mr. Conrad?
No, Your Honor.
So they can do that at least. Okay. Otherwise, you have no objection to any of this, Mr. Unruh, is that right?
That's correct, Your Honor.
Motion to prohibit the state from mentioning Officer Burbank's decision not to testify?
State will not be doing that.
So they can grant that too, huh? Okay. Motion to prohibit the state from arguing that Officer Rankine kneeled on Mr. Ellis for 6 to 10 minutes or for any specific amount of time. Claiming there's not you could not have a good faith basis to claim that Officer Rankine kneeled on Mr. Ellis for 6 minutes, 10 minutes, or anywhere near that amount of time, is the way he puts it. What do you say to all that?
This is a factual matter in dispute, Your Honor. There's, the defense is, and the state is free to argue their theory of the case based on the facts presented during trial. And we have evidence that Mr. Rankin arrived at the scene at 23:24. He indicated that he had his both knees on top of Mr. Ellis until fire arrived, and that's when he rolled him into recovery position, which was at 23:34 for 10 minutes. And, the parties are free to argue what the evidence showed in this case, and then we have this matter of Mr. Conrad arguing about this 8-minute, 30-second duration. But these are the facts. I mean, we will argue our theory of the case based on the facts presented.
So, state objects to your motion. Do any of the other defendants have a claim about this? I mean, obviously, you have an interest in this particular motion. You were going to say anything about it, Mr. Purcher? Or Mr. Fricke?
Well, Your Honor, I'm not going to step on anyone's toes, but, I guess I'll address what I believe the facts indicate.
Well, which should I grant this motion?
I'll refer to the court, Mr. Conrad.
Okay.
Well, I think you should, Judge, because I think the state's limited to an argument based on rational inferences from the evidence. I don't give any evidence that support an argument that Officer Rankine sat on Mr. Ellis' back for 10 minutes, or any specific amount. That's not the evidence.
I think Mr. Lewin just limited it to about 8.5, but go ahead.
Well, but even in that 8.5, the court knows specified for the amount of time. So I think the specific arguments about how long and how much weight and those sorts of things aren't supported by the facts. They can say, for some time, we aren't sure what that time is, but 10 minutes, 8 minutes, 6 minutes is just not supported by the literature.
Well, I'm not sure what the state's going to say about that. Mr. Conrad, do you have the last word on this since it's your motion?
I just think that argument needs to be tethered to facts, and that becomes completely untethered from facts, because the court's been sitting through this trial, and I think we've heard the testimony, and it's not accurate. And the prosecutor's argument has particular weight to it, and I think that they have to have a good faith basis, and to state such facts when they're unsupported wouldn't comport with that.
Well, of course, what they say is it has to be tethered to the evidence in the case, yes. But whether or not Mr. Liu or whoever's doing the closing on behalf of the state is able to craft the information in a way that maybe doesn't appear to me or to you at this particular moment to be a precision, they might be able to make some reasonable inference as to a time range, for instance. And so I guess I'm not in a position to grant this. I'll deny this motion. Motion to prohibit the state from arguing that Officer Burbank's statement contradicts Officer Rankine's statement or testimony.
No objections.
That'll be granted. Motion to prohibit argument that Officer Rankine is liable for use of the spit hood or hobble.
State opposes. State is not arguing that Officer Rankine put the spit hood or the hobbles on, but it was placed on Mr. Ellis while Officer Rankine was on top of Mr. Ellis and in control of him. Mr. Ellis is in Officer Rankine's care. He has caretaking functions towards Mr. Ellis. It was reckless for him to leave the spit hood and hobbles on. And also, when it comes to reasonable alternatives for the use of force, he needs to consider whether those items should have been removed or not. I mean, it is an important part of this case, and the state should be able to reference these arguments.
Last word?
I mean, Judge, there's been no evidence whatsoever that Officer Rankin requested the spit hood, that he's had any training on the spit hood, that he's ever used the spit hood, and to suggest that he's the conduct of another person in that scenario where he doesn't have any knowledge about what's being done, and he has a sergeant on scene, to suggest that he is responsible for the actions of other officers and that he's also not an accomplice to, I think, is not an accurate statement of the facts, and it's not an accurate statement.
Well, there may be sort of a semantical thing here, a little bit. You're asking them not to comment on his use of the spit hood or hobble. And I think what Mr. Liu is saying, well, and I'm not sure the state's going to claim that Mr. Rankine was involved in initiating either the use of the spit hood or the hobble, but what they do claim, I think, is that the fact that those things were used was known to Mr. Rankine, and the fact that those things were used may have had an impact in what actions Officer Rankine did take or should have taken. And so to that extent, maybe it's not the use so much, but the fact that they're there is part of the entire circumstance that Officer Rankine was facing when he was making his decisions. They certainly have to talk about that. The spit in particular is, I don't know, there's been kind of an interesting aspect of all this, in that we haven't had a lot of information about what the actual effect of that was, although we did have Dr. Clark's autopsy report, or maybe it was his report actually as an expert for the state. Anyway, one of those reports, and it was just testified to, especially during his examination, that he identified the spit hood as possibly a very determinative aspect of all this. It might even be the cause of death. I think it's, in so many words, he kind of said that. He didn't say it that way, but certainly the testimony that there hadn't been any training, and that sort of thing by Officer Rankine is certainly also in the evidence, and I don't know that there's any evidence contrary to that. So, I don't know, you can say that, but the state can talk about the use of those things and what an Officer Rankine, although I think Officer Rankine actually denied knowing the split hood was on, or at least seeing it placed. Maybe he knew it was on, because I think he said he saw it removed by medical folks. But in any event, so that may have some bearing on this too, but I'm denying this motion. Motion to prohibit the state from using hearsay statements relied on by experts during closing arguments in violation of Rankine's confrontation rights. Well, that was the proposed instruction, kind of, that we just talked about. I'm not sure, I'm not sure how you parse that in closing argument, especially. You might be able to parse it a bit during the testimony itself, but now that we've got the closing argument, you sort of have to talk about all this stuff and the conclusions, and to the extent a conclusion might be based on all that, where do you draw the line?
Well, it wasn't being offered for substantive purposes, it was being offered to understand what the factual foundation for experts' opinion.
Sure. Well, the opinions of the experts are substantive evidence, I think, but we do have, of course, an instruction about the consideration of expert testimony witness, and the jury's free to credit it or not credit it as they think best. It tells the jury they're not required to accept the opinion, and gives them some ideas under how they might determine the credibility and weight to be given to this type of evidence. I won't read the whole thing now for the record. We all know what it says. It's the proposed instruction number 6. I'm sorry, this is Winnie's handwriting here is a little fuzzy. I think it is instruction 6. Looks a little like a 5, but on my copy at least. Anyway, so I'll deny that motion.
I'm going to make one additional oral motion, that's to prohibit the state from burden shifting in closing argument, to suggest that we had some obligation to call witnesses as the non-testifying officers, the non-defendant officers.
The state would not be making such arguments, Your Honor.
Sometimes we get a missing witness instruction, but I'm not getting that here from anybody. But I guess I would say this, Mr. Conrad. I mean, in general, no one has an opposition to what you're proposing, but one of the things that I've noticed about lawyers is that language is malleable, number one. And number two, burden shifting is a particularly malleable defense argument. And I've seen it used and employed in lots of ways that would not immediately come to one's mind. So I'm a little reluctant to grant that and then have some novel explanation of burden shifting be argued, and therefore an argument, and then in violation of the order in limine. To the extent we're talking about the defense having the burden to produce any particular evidence, I think that's right. And Mr. Liu's not going to go there. He's nodding his head in agreement. So certainly we know what has been produced, and he might say what we know or what we don't know from that. But he can go there, I think. So to that extent, I'll grant your motion. Ms. Fricke, you look like you want to say something.
I was hoping to get some type of game plan that the court has in mind for closing jury.
I'm playing this by ear too.
Yeah, my understanding is Ms. Eakes, who's doing closing, thinks she has approximately 2 hours. Of course, things change when you're up there, but assuming that's the case, and assuming she doesn't start till 1:30 or so.
But right now, I'm thinking she's not gonna start till closer to 2, maybe even
I
2:30.
just don't want to get in a situation where I'm going next and I'm splitting mine from late in the day till tomorrow morning.
It depends on when it falls, Mr. Ricky. You may get split and you may not. I guess it depends on how much time it is. I don't wanna lose any more time than we've
Sure.
lost already. And, these things are always getting older and older and therefore fuzzier and fuzzier in the minds of the folks who've been listening to the information in this case. So the fresher, the better, it seems. Even if it's just a matter of a few hours, if I can avoid it.
I was thinking it's like 3:45 or so,
Okay,
something like that.
We'll see.
I'll make my request.
well, it's like anything else, there's a principle of some prudence, and which says, don't make hard and fast rules about things. You sort of need to make judgment decisions based on hopefully sound and tried principles, but you got to apply them to specific facts to see what the right outcome is. So we'll see what the facts are.
Can I request?
Sure, and I get the idea. I mean, what you're asking for is not something novel. It's something that's certainly routinely heard of. Judge, please don't make me split up my argument because I kind of lose the thrust of position that I'm developing with the jury. So I understand that. So we'll try not to do that, but at the same time, not waste too much more time. Okay, we can't do anything else till Mrs. Winnie gets back, and I'm guessing by the time she gets back and hands us all out, we're going to probably be at noon. I'm going to have to read all this to the jury, of course, next, but we also have to put those exhibits on the record, which we haven't done yet. But who knows, maybe they come back just to do that. It depends on when she gets back here. Why don't we wait at least a few more minutes and see whether we can at least accomplish that much with the jury this morning. I'm not going to grant this at this point. The jury instructions will be made a part of the public record, and anybody can get them, and get them. They'll be in the court's file. If I was to make instructions for lots of people, this stuff becomes a fairly expensive proposition and time-consuming. But you're going to hear them, because we're going to read them out loud, and everybody's going to be able to know what they say.
There's one issue with respect to the state's PowerPoint that I wanted to raise.
Oh, good, sooner the better.
So the state provided a copy of their PowerPoint today. There's a number of photographs that are in the PowerPoint of witnesses while they're on the witness stand. I believe those came from media photos. Obviously, they're not admitted exhibits. My concern there is that it highlights the public nature of this trial. And so I'm not sure it's appropriate to have those.
Why, because the source of the photograph is a media source?
I mean, they're not photos, obviously, they're not photos that have been admitted, but they're photos of the witnesses.
No, I understand. Hopefully they're reasonably flattering pictures. But I can understand the point of having that, it's just so you can remember. Remember when this person testified, instead of just a name? Look, this guy, this person we're talking about. And so it hopefully helps with our recollection of what that person said. I don't necessarily of itself see an objection to that. Ms. Eakes?
Yes, that's right. That's correct, Your Honor. That's the reason why we have them there. And
Especially given the duration of the trial.
yes, exactly. So,
And the fact that there's public interest in this trial is certainly not going to be lost on this jury, regardless.
they can see the cameras.
Yeah, they've known about it from day one. It's something we talked about during jury selection. It's not a surprise.
There are, I apologize, the court's,
I'm done.
okay. There are a couple of issues with respect to the defense PowerPoints that I just wanted to flag. In Defendant Burbank's PowerPoint.
Of course, I don't have them, but do I need to see this, or can you just make your argument without me looking at it?
You probably will need to look at it, but
Okay.
Hand up my copy.
By the way, while we're at it, while you're getting me a copy, does any other defendants have an objection, anything else in the state's PowerPoint?
I don't, Your Honor.
Judge, no, Ms. East has sent it 7:30 this morning. I reviewed it, I don't see anything objectionable.
Okay, go ahead, Ms. Eeks.
So with respect to Defendant Burbank's PowerPoint, there is a reference in here to Graham versus Connor. And since the court did not instruct on that, the state doesn't think that it's appropriate to have that in there. With respect to Defendant Rankin.
How big of a reference is it? Because, I mean, it was talked about,
It's a slide. I can hand it up to the court.
yeah.
That's my only comment.
I'll let you have it back in just a moment.
If I may, or, well, I'll let you review it.
Leonard, can we get the microphone? Can't hear a lot of argument.
Well, I'll ask them to do it when they're talking. Okay, you wanted to say something about this?
No, Your Honor, it obviously was part of the case. It was part of the expert testimony from both experts about that case. I'm not suggesting that is the law in this. You're giving the jury the law, but I am suggesting and will suggest that certainly was part of the opinion given by Ryan in particular, and his statement of the law in the context of that case is simply wrong. And so I think, and they talked about it ad nauseum, so it's clearly factual. But it's not referenced as it's the controlling law in this case. Obviously, that's through the instructions.
I don't know, this makes a whole lot of difference. I suppose what if you changed it to, I mean, this is where this all came from. Everybody seemed to agree on that. I don't know whether this is a truly accurate description of Graham versus Connor, but in any event, whether it is or it isn't. Verbatim?
I believe so.
I don't know, but it's a long decision. It's not just.
Well, I certainly didn't know.
But having said that, would it be better for everybody if instead of Graham versus Connor, just said use of force
Fine with that.
as the title to it? That would not be objectionable, I take it?
No, that's fine, Your Honor.
Okay. See if we can change it to that.
I have no problem with that.
Okay, great, we'll do that.
And then with respect to Defendant Rankin's PowerPoint, there are a number of things. First of all, and we chose not to do this because it was our understanding that the court did not want things to appear as if they were transcripts, testimonies directly from transcripts, because the jury, of course, doesn't, they're supposed to take their notes and you can't read back from the transcript.
Yeah, as I understand, I guess I say for the record, my understanding is that all the parties in this case have been receiving daily transcripts. Not necessarily?
Judge, I haven't received a single transcript or anything.
Oh, okay. It's a special thing that people can pay for. And the reason we've had two reporters is so that Ms. Sanford can do her transcribing, or her reporting rather, here in our courtroom. And then in the afternoon, she can try to transcribe what was done this morning to provide it to the parties. The state's certainly gotten them. I've gotten some other transcripts maybe from, I think the defense has at least gotten some of this, maybe not Mr. Usser, but some of the others. And then Ms. Flygar in the afternoon would do the transcribing of all this, and then, or reporting rather of all this, and then transcribing her afternoon deals the next day, and then providing them to folks. And so, just so that the record explains that. So go ahead, Ms. Eeks.
Well, Your Honor, it was our understanding that the court would typically not allow there to be like clips of transcripts that are truly just from the transcript, as opposed
Yeah, I tend not to like that, in part because the transcript has usually not been certified, because the reporters usually don't have enough time to go back and check it for errors, spelling, typos, that kind of stuff.
Right, so that's what our objection is to. What we did is just kind of get rid of the quote marks, so to speak, and just summarize, what a witness had said, or as close to it, but not make it look like it came from a transcript. So we have a concern about Defendant Rankin's PowerPoint having it and it's throughout, with just actual screenshots from a transcript.
Sure.
So that's one issue.
Well, let's
address that right there?
We'll do one at a time.
Well, Judge, they essentially do the same thing, which is they do I don't know if the court can see this, but it's question, when would you leave someone in the prone position? Answer, almost never. So that's the state's PowerPoint where they're quoting from the transcript. And in fact, they're not taking the full quote. I mean, they have access to the same materials I do. And so I feel like this is the pot calling the kettle black because they're doing the exact same thing.
How's it different?
Well, Your Honor, again, I thought that our understanding was just that you didn't want it to appear that there were transcripts so that the jury could think that they could come back and read the transcripts, as opposed to, like I said, we took away the quotation marks and just kind of did question and answer. Sometimes we just summarized it, but sometimes we did.
So if we change the font and we take the quotation marks out, then Mr. Conrad's version would be fine? Well, let me just answer that question. Would Mr. Conrad's version of it be fine then?
Yeah, I don't actually have an objection to the content. Again, it's just the question of whether or not the court wants the jury to see that there are
Sure.
actual
Gotcha.
transcript
Any objection to doing that, Mr. Conrad?
Judge, I'm gonna have to go back and redo my whole PowerPoint because instead of,
Why can't you just do those particular slides? Or is your whole
I
PowerPoint?
mean, my PowerPoint has it, when I'm summarizing certain witness testimony, I wanna point out specific testimony that the jury has heard, and so I've taken from the transcripts with that regard. Like, an example is, I looked this morning and saw.
Well, hold on a second. You don't want to do it is what you're telling me, not so much that you can't do it.
It's gonna take me I mean, I have 60 slides.
And are all 60 got quotes on them?
I mean, I have a lot of quotes in there from what the testimony was, from what the state's experts were.
Well, you can hit Command All and change all the fonts.
I can't because I'm taking I mean, I'm trying to be as accurate as possible, which is, I'm taking the actual quote from the transcript, so I'm taking a screenshot of what it says within it.
Oh, it's a screenshot, it's not a Word document.
It's not a Word doc. And so the state has instead just taken the question and the answer that they like, while maybe leaving out other portions of it. And I'm like, well, look at the full picture here. And so I think that's really important. I think it's quite compelling, especially when you see some of the quotes that the state is using when they don't give the other, what the next question is, what the next answer is.
All right, I guess I will take a look at it. Go ahead. Mr. Fricky, can I use your copy? You're the one who offered it.
Well, as I can tell you, they may say it's not quotes, but they sure make it look like quotes. And probably where you can, well. But there's a whole bunch of slides here where they have a question as if it's a quote, answer as if it's a quote, throughout their presentation.
If the court
Well,
wants, I can also-
this is the state's stuff you're looking
That
at.
is the
I can
state's.
end up ranking. I thought that may be what the court was asking about.
That is what I was asking.
So that is at a minimum misleading. Come out here and suggest these aren't quotes when they, other than the quotation marks, make it look like a quote.
Well, I agree with Ms. Eeks. Make the changes, Mr. Conrad.
This is the first I've heard this court's preference. So what exactly?
Well, regardless, that's my ruling. You got to at least till 1:30. You probably got till tomorrow because we're going to have a situation where Ms. Eeks, I'm going to read these instructions to him. That's not, at this point, going to happen until 1:30. Ms. Eeks is going to go probably take up the whole rest of the day, but if not, very close to that. So if Mr. Fricky starts going, who I understand would go next, you've still got till tomorrow to get these changes done.
Sure.
So you got time.
Judge, what do you want me to do? You want me to remove the numbering on the side? Can I just
Yeah.
keep it in that spot? Can
I don't much care about the font, although it should be consistent with whatever else you're doing.
I do question answer the way that the state has been doing it?
Yes, I'll let you do that.
So as long as the numbering is gone from the side, so it doesn't look like it's coming from the transcript, of course, okay.
And you've got this little picture around it, which also makes it look like it's a photograph. So you gotta take that out. You gotta make it look like it's been pre-written.
Okay. So just the words, not.
If it'll make you feel better, take a look at what Ms. Eeks has done and go ahead and follow that format.
And some of them actually even have objections and then the argument about an objection in them too, which I again, think is kind of problematic.
Counsel's argument?
No, I think there's one in there that I tried to cut out, but it just says objection and then. like, it says
Because you took a picture of it. You'll be able to fix that now. Another good idea to why we're doing it this way.
So, question, answer, as long as it's not superimposed in that way. Can I do it for the jury instructions?
You want to take a picture of the jury instructions? You can do that if you want. I don't mind you picturing the jury instructions. You can also just say, look, please turn to juror instruction number 14 or whatever it is. And they've got they're going to have a copy, as you know, in front of them, so they're going to be able to turn right to it. If you want to stick it on your PowerPoint, that's fine too, and I don't care if that's done as a screenshot.
Okay.
A couple of other issues that the state has when the court's ready.
Go ahead.
With respect to Officer Rankin's PowerPoint. They have a timeline in here. It references an exhibit that, number 44, that I don't believe is an exhibit that's been admitted.
I don't know, now you're going to make me go back and look at that.
That's a mistake. It is. I'll just remove that, that's fine.
Yeah, I think that she's right.
That's a scrivener's error, Judge. I can remove it.
Okay,
44 doesn't have any particular importance.
all right. So I don't know if there's another exhibit you're intending to reference there.
It was 444 is what I meant to type in there. Maybe. I actually checked my notes.
444 was admitted. It's a video of police at the scene. And it was offered at least and admitted during Mr. Frederick's initial testimony. This came from Ms. White.
That makes sense.
That's what 444 is. There were a couple of different sort of timeline things that were offered. Five, 4, 6 was a kind of event timeline. There was the CAD report. .33A had a kind of timeline to it. 898. Not sure that all those were admitted, but some of them were. 569. And there were others, I guess. Anyway, so I'm not sure what you have in mind there, but
And then there's also a slide that says methamphetamine levels, and it has, I'm not sure where this information came from, but it has Manuel Ellis, then it says therapeutic, and then it says lethal, and it has 1,000 on it. And I'm not sure if that came from a study or something, but I don't believe that's what the testimony was. Okay.
well, he did talk about that, which he described as 0.05 milligrams per liter, or per milliliter. He said he actually said there was a range of 20 to 50 nanograms. with 50 being the high side. So I don't know, and of course, but then when you change it to, if you change the conversion from the 50 to the, you're talking about nanograms to milliliters, so you're now talking about a different number. You're adding 1,000 or 100 times or whatever more.
So he also testified, Judge, that the lethal range pursuant to the studies that have been conducted is typically 1,000 nanograms.
He did say that 1,000 or even less, he said, could be
They
lethal.
say even less.
Yeah,
And so I'm entitled to argue those facts.
right. But I'm not sure exactly what the deal is here. I thought the claim was you were saying that 1,000 was therapeutic.
No.
What does it say?
It shows 1,000 as lethal.
He said 1,000 could be lethal. That's my note of Mr. Lewis's testimony.
Okay, I wasn't sure where it came from, so, because it looks like it's as if it's some sort of a chart that comes out of an article or something like that.
Yeah.
And then the final objection is with respect to a chart that they have that relates to beyond a reasonable doubt, but it starts with reasonable suspicion, probable cause, preponderance, and the state just doesn't think that that's appropriate with respect to the various burdens of proof.
A pyramid? Can I see it, Ms. Eads?
Sure.
Thank you. You have any comment about this, Mr. Conrad?
Judge, I've been using a chart like this since I first started out with.
So,
And I used to draw it on the board and do it that way, to explain to the jury what the different standards are in the legal field.
Yeah.
I mean, I don't see why the different standards of proof.
Here's the deal. I think. It's not that there's just a listing here. The pyramid creates a quantity.
Yeah, sure does.
Which may or may not be reflective of these particular standards.
I mean, I think the case law supports the fact that, and the instruction supports the fact that beyond a reasonable doubt is the highest burden that we have in this country.
I think if this had just been straight bars across without a pyramid in the end of it, then I don't know there'd be any problem with this.
But isn't that the reality of what beyond a reasonable doubt means? Is
No.
that there are only,
Not necessarily. Because it isn't just that, you've also got, the idea is, for instance, preponderance. A preponderance is more than 50%, right? 50%, and a little bit more is a preponderance, right? Is the area under the pyramid, among the period, from preponderance and up, I'll give you, is that 50% of the size of the pyramid?
no, but the
It's
pyramid is not
it's less than 50%, right?
The pyramid's not necessarily reflective of how many cases.
Then you won't mind taking the pyramid out.
I mean, if you look at okay.
That's the problem. It isn't that these things are listed in this particular order, I don't think. You could list in this kind of order, and as far as I'm concerned, if these were bullet points instead of your pyramid, I don't think we'd have a problem here.
Well,
The pyramid tends to quantify it in some way, which may be at variance from the law. And that, in that sense, it could be misleading. I think that's misexplained.
That's correct, Your Honor.
I think I said it better than you did.
I think you did.
So, yeah, no pyramid. I'll hand this back.
so you just want me, if it's just a rectangle, it's okay as long as.
If the bars go all the way across the page, as far as I'm concerned, as long as they're not formed in a triangle or some other kind of geometric shape which suggests the quantification of each amount of these levels.
Okay. Is that it?
I'm sorry, was that right? Is that all, Ms. Hicks?
That was all I had.
Okay.
There's one other issue with the state's PowerPoint, which I failed to mention. There's a slide in there with Mr. Ellis's sister, and it says in there, and it's quotes again from the testimony. It says that he was my person. He was always there when I needed him. I trusted him to watch my children. And then it's a picture of his sister on there.
Any comment?
She testified to all three of those things, Your Honor.
Well, yes, that's true.
How is that relevant to the elements of the charge and the facts of this case as to whether the conduct meets, and not only the conduct, but the mens rea meets the elements of the charge? It's directly going to trying to invoke sympathy to the juror, which I think would violate the first motion. It's one of those motions that we just filed.
Well, I don't know about the first one, but I understand the third one.
Sorry, I meant one.
The motion limiting that the state, after we clarified that the word tragic could be used, the motion limiting had to do with prohibiting the state from making sympathy arguments, saying that she trusted him with her children. Is that a kind of a sympathy argument?
Well, Your Honor, it's actually not going to be used as a sympathy argument. It's simply to address the issue. I mean, Mr. Ellis is obviously the victim in this case.
I'm sorry, say that last word.
Mr. Ellis is obviously the victim in this case.
Right.
And the jury heard,
I realize there's an argument about whether or not he's a victim at all from the defense point of view, but I'm going to allow the understanding, Ms. Eakes, to speak in plain language. Go ahead.
yes, I mean, and the jury is allowed to, we're allowed to remind the jury a little bit about what they heard about Mr. Ellis as compared to what the defense has been wanting to put on about Mr. Ellis. So it's just as a matter of addressing that. Just giving a brief summary of who he, what the testimony was about him. Because frankly, there wasn't a whole lot of testimony about him from the state. It's mainly been testimony by the defense as to the negative aspects of him, shall we say.
Well, for instance, in Mr. Conrad's motion, he says, which we glided over for the sake of expediency here, but he says, in the second paragraph, the sole issue for the jury to decide is whether the state has proven beyond a reasonable doubt that Officer Rankine's actions on the night of this incident fulfill every element of the crime charged. Therefore, any appeals to sympathy for Mr. Ellis's family, supporters, protesters, or the community are improper. The state should be prohibited from commenting on Mr. Ellis's family or anyone else's efforts or desire for justice, their pain or suffering, their need for closure, or the consequences to them should the jury acquit the defendants. In fact, the state has no reason to even mention Mr. Ellis's family except as it relates to the substantive evidence they provided. They should be prohibited from doing so. Well, I've said, well, that's a little far because I can at least point out this is tragic. But suggesting that Mrs. sister is now out a babysitter, I don't know, repeat it to me again, what was it
not being
exactly?
used
What
as
exactly have you got?
evidence, Your Honor.
Say it to me again.
It's really to rebut the notion that the defense has raised that he was just a psychotic meth addict. There's very little testimony about Mr. Ellis, given the court's restriction on it. And this is just simply one of the few things that,
Well, read to me again what you proposed to say.
just what is on this slide, just that Mr. Ellis.
I don't have the slides, you guys didn't.
Oh, I'm sorry, I apologize. It says, he was my person, he was always there when I needed him, I trusted him to watch my kids. That's all the slide says. That was her testimony on those, about him.
For the record, Your Honor, I don't have an objection to it.
Okay. I would say you can say all of it except, you got an argument here, Mr. Usher? Okay. I would say you could put a period after the word "I trusted him." The business about watching the kids. The rest of it all stays in.
I trusted him.
Yeah. She trusted him. Is that improperly editing her remark by putting it there?
I mean, if the court's gonna leave it at that, then we might as well let the whole sentence in. Because,
Well, then I will.
I mean, it doesn't go to any element of the crime charge.
Well, that's my ruling. You can argue about it if you want, or you can, and I can, and if that's what you're doing, then I'll say we're done and we're gonna move on now. If you have some suggestion about whether or not I've somehow improperly edited her remarks by putting the period there, then I'm willing to hear that. If you'd rather I not put the period in and leave the whole thing in, I'm sure the state won't complain about that.
I'd rather just leave the whole thing.
There you go. Leave it alone.
Thank you.
Anything else that anybody has with respect to the PowerPoint says to each other? Okay. We're about 12 minutes or so past noon, so we'll take our noon recess, and hopefully we've got our copies here, so we'll be able to distribute those and give them to the jury. We'll try to make sure we get these exhibits admitted in their presence.